Because I truly believe that the litigation system around the world as it is developed right now, it does not serve the needs of the clients appropriately, and arbitration can be used as a tool in order to expedite the process and to limit the amount of issues that clients face. The number one key development in Italian arbitration is the new rules that are implemented and entered into force on March 1st, 2019. And then they are probably the most important keys for understanding the Italian environment, because, of course, the main part, the Milan Chamber of Arbitration is the main arbitral institution in Italy. And these new rules, as I said before, they are designed to harmonize the Italian system together with the international system. Key features of these new rules are the interim measures that finally were implemented in the Italian system. Of course, they were also already into place in 2010 with the previous rules, but now there is a very interesting feature that was added with these new rules, which is the final decision that can be made by arbitrators and that can be seen like a contractual obligation upon the parties. The other important key element is the emergency arbitration. So there are, which basically features a new facet that can be seen like an harmonization towards international arbitration. And there are other final touches that can be looked upon. For example, third-party funding that finally was implemented into the new rules and can give a big boost to the entering of capitals where clients cannot afford litigation, especially in this case arbitration. The most important foreign users regarding arbitration in Italy are by far companies involved in the luxury business and pharmaceuticals. Regards has to be given also to oil and gas companies, of course. Regarding the second part of this topic, I would like to address the fact that a tremendous boost can be given to these users based on a couple of approaches. The first one are the new rules implemented by the Milan Chamber of Arbitration, as I said before, that are giving more powers to the arbitrators as far as expediting the process, and also as far as the time schedule of the arbitration, and then can lead to predictability. At the same time, there is another feature in the Italian arbitration system that is very well known to the international businesses, which is the fact that very rarely arbitral awards are going to be challenged, and this challenge is going to be upheld by the Italian courts, because our country is a competence kind of system, so only arbitral tribunals can decide on their own competence. These two important facets of the Italian system can make the Italian arbitration system tremendously appealing for clients. To me, the Singapore Convention is something very close, because I think can give a tremendous boost to the alternative dispute resolution mechanisms as a whole. You cannot see arbitration, you cannot take a look at arbitration without taking into consideration mediation and negotiation, which are the other two main prongs of the alternative dispute resolution methods. With my clients, I always advise them that multi-tiered steps should be a clause to be implemented in the contracts, because you have to use all the skills that the alternative dispute resolution methods provide you with in order to be able to tackle these issues and to address them properly. The Singapore Convention was signed on August 2019, and in Singapore, of course, and was signed by 46 states, and is going to enter into force 6 months after the third states will ratify the convention, and it's designed to be a regulatory framework which will boost the mediation proceedings in general, because the main point of the Singapore Convention is that they are going to give full recognition and enforcement to all mediated settlement agreements of course in cross-border transactions. So it can be seen like an ally for the arbitration system, and can also be, as a competitor, raise the standards in order to make arbitration a bit more flexible, which is to me a tremendous need in arbitration. The Singapore Convention on Mediation is by far the most interesting development in the ADR system right now. The main point of this convention is to design a regulatory framework in which there is the recognition and enforcement of all mediated settlement agreements in cross-border businesses. So this can be seen as a very strong development in the ADR system, because arbitration can look at mediation as an ally more than a competitor in order to implement all the kind of flexibility that mediation allows to the system.